Hello everyone, welcome to Knowledge Skill. This is me Sayyid Shudatullah, your educator. Yesterday there was a judgment from Rajasthan High Court that has drawn criticism from various quarters of society, especially from the women rights activists and organization. The judgment reads in this way: removing minor girls' innerwear. Okay, any individual in our country who has not completed 18 years of age, whether male, female, transgender or belong to any queer community, all of them are called as what? Minor in our country, according to the law. So removing minor girl's innerwear and undressing oneself in front of her does not consider to be called as rape, does not consider to be called as attempt to rape. This is a 33-year-old case and the judgment has come now. So you just understand the way the judicial process has been delayed over a period of time, maybe because of lack of evidences, maybe because of lack of witnesses, maybe because of the money power that has actually dragged and gave 33 years of life to that individual who has removed the innerwear of that minor girl. Just imagine the way the society and way the judicial process is actually doing delayed justice. There is a quote is there, no, delayed justice is actually injustice. That is what has happened. Right, let us get into the topic now. The court ruled that the act would attract the offences of outraging the modesty of women punishable under section 354 of IPC. IPC stands for Indian Penal Code. It is a book according to which a person's crime will be judged and he will be punished. Okay, for life sentence, for imprisonment, for 5 years or for 10 years, whatever it is, a person's crimes will be judged according to this IPC Indian Penal Code book and he will be given punishment accordingly. Okay. Now the girl and the advocate representing the girl wanted the person to get very stringent punishment, but the court has observed that this particular whatever the activity done by the man does not actually considered to be called as a rape. That's why he will not be punished according to sections which are very stringent, which give stringent punishment, but he will be punished according to the offense that is called as outraging the modesty of women, punishable under section 354, which is nothing but a lenient clause. Means the person will not be punished a lot in this particular section 354 of IPC. Now it is important to understand here that outraging the modesty of women is nothing but making the woman uncomfortable. Doing a job, doing something which is actually making the woman uncomfortable. That is called as outraging the modesty. Maybe you are tearing her or taking her chunni. If you take the chunni of the woman, she will feel that her modesty is infringed, right or wrong. So if you are doing these kind of activities, then it is called as outraging the modesty of a woman. So this particular person will be judged under this particular crime, which comes under the section 354 of IPC. But the minor girl and also you can say that the advocate wanted this man to be booked under very harsh punishments and very harsh sections. Let us see what has happened in this story. This case, which dates back to March 1991, remember this point, from a district of Rajasthan, where the complainant, the 6-year-old granddaughter, was accosted by the accused Suvalal when she had gone out to drink water around the well at 8 p.m. in the night. She took her to the nearby Dharmashala and removed her innerwear. And after removing her innerwear, he also removed his clothes. That was the case, and girls started shouting by seeing that man naked, and also he removed the innerwear because 6-year-old girl, little bit of some kind of consciousness will be there whether some things are going right or wrong. So based on her beautiful consciousness, she started shouting and the villagers came and rescued her. This was the event happened, and obviously when it was in the public domain, he has been booked under what? Police station. Now you guys have to see this particular sections very, very closely. I'm talking about one section called as IPC sections 376. Another section that we have to read here is section 511. Another section we have to see here, section 334. Please concentrate on this. The total lecture and the case progress and the judgment will rest on this particular sections only. Now the minor girl and the advocate want the person to be booked under very harsh sections, which actually gives very harsh and stringent punishment. Like IPC section 376, it says that whoever commits sexual assault, means whoever tried to commit sexual assault, means the urge to have sex with someone, forcefully removing the clothes, forcefully kissing somebody, forcefully holding hand, forcefully touching your genitals with the woman body, that is called as sexual offenses. Please try to understand my words very clearly and comprehend it. So IPC section 376 says that whoever commits sexual assault would face not less than 7 years of imprisonment. This is one point you have to remember. And section 511 says that applies to attempts the person anybody commits, okay, will be imprisonment, which give harsh imprisonment. So any attempt of offense will be booked under 511 and sexual offenses will be booked under 376. There are two sections are there which actually prescribe maximum and also what stringent punishments of 7 years to 10 years. But in this particular case, what has happened, the court has not used this section, the court has not used this section, which the minor girl and the advocate want the person to be booked under these sections. But the court has said that no, this is not the section that actually need to be invoked on that particular person, because he was in the preparation stage. Before that only he was stopped. Okay, that's why these sections will not amount to any sexual offense. It was a normal offense that we will consider, and we will give the reward of punishment in the same manner. That was the court, okay, observation. The court ruled that the act would attract the offense of outraging the modesty of a woman. So court has used here very simple section that actually prescribes lesser punishment to the individual. That section is called as 354. But the minor girl and the advocate, okay, who representing the girl, want these sections to be invoked against the man. But the court has taken what the section 354 and consider the act done by the man as a act of outraging the modesty, making the woman uncomfortable by doing some act. Okay, so that is how the whole thing happened. So after coming this judgment, what happened? Many of the social activists, especially from the women organization, has criticized this particular judgment and said that this is not right. Why? Because in the later case, one case was already there. Okay, there was a similar case in which of Chatu Lal in the state of Uttarakhand, where a victim adult, Vijay Goel, okay, child right activist in Jaipur, says the Supreme Court convicted the accused for offences under section 354, section 511, okay, within the section 376, along with the victim as an adult. So this particular event of undressing a woman, okay, a major woman who has crossed 18 years of age, the Chatu Lal has done this particular with the adult woman, removing her dress. At that time, the court has given stringent punishment to that particular man, whereas the court has not given the same punishment to the minor girl. Why this discrepancy in the judgment has happened? That was the contention. Okay, and it is also being said that at that time, the court has taken this view. Why? Because at that time, POSCO Act was not there. Okay, Prevention of Child from Sexual Offences Act was not there. This act came into being, this POSCO Act came into being in the year 2012. Okay, and the case belongs to what? 1991. So at that time, this particular act was not in existing. Otherwise, if this act would have been there at that time, he would have booked for life. Okay, so the court has taken a very normal and very understanding view here, because when the law does not exist, how can you actually punish the person? So there is a procedure, there is a constitution is there in our country which always says that procedure established by law. Any person's crime should be judged according to the procedure established by law. So there is no procedure at that time, there is no stringent law at that time when the incident was committed. That is the reason the person has been given lesser punishment in the section IPC section 354. This is all about it. Please spread this news to everyone. No need to worry about it. Now we don't have these kind of rudimentary acts. We are now having POSCO Act, where this kind of undressing a minor's innerwear, or taking out a chunni of a woman adult, or trying to grab the boobs of a woman, okay, trying to touch your genitals with the woman, these all will be attracting very, very, very severe stringent punishments. So all women who are hearing me, no need to worry about it. You are good to go. Bye bye. Take care.